The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Lawgic. Before we get into the main part of today's lecture, the main part of today's class, and today is a class. It is a class. That's I can't help it. It's a class that I think every American should take, honestly, but it's limited to a select few hundred, thousands, whatever, who will actually watch this. It's a necessary class for you to understand principles of immunity, and I'm going to make it so this very amorphous, complex legal thing. I'm going to do everything I can to make this just crystal clear, crystal clear, crystal clear, crystal clear. Boom, 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 boom. I actually did preparation for this one. You're going to see it soon. I'm going to unveil that. But before that, there's a funny incident that happened last week, and the events folded over into this week, and we were supposed to get some sort of update on it. Many of you may be familiar with this story. Some of you may not be. It was actually broken down by a good friend of mine, friend of the show, Robert Gouveia, who I am a huge fan of. Whatever level fan you are of Robert Gouveia, I'm probably an even bigger fan. Unless you're like, living with the dude. Which, okay, in that case, let's not get crazy here. he's great talent. He really is. And I saw a clip of his that I actually shared. I'm going to share it with you now because this is the preface to this story. I really don't have to share screen if you're going to know what the heck I'm talking about here. So let's do that first. And not inviting. I'm going to present the screen. That's the way to do this. And share. All right, here we go. There's my buddy. There's my guy. All right, let's make it a little bigger.
Former lawyer.
Yeah, let me refresh that. I do. Okay.
Michael Cohen, Trump's former lawyer, his lawyer was busted, says. On November 29th, David Schwartz, counsel for Michael Cohen, he filed a motion for early termination of supervised release. Now,
meaning he's already been released, but he's under supervision, and they're supposed to be under supervision from that release for his prison sentence for, I don't know, sometime into the future, which Michael Cohen thinks is too far into the future, and he made an application to the court saying, I don't need to be supervised anymore. Just let me go. So that application was filled with all sorts of, different legal decisions, like United States versus Figueroa Flores.
Now, in the letter brief, Mr. Cohen asserts that, quote, as recently as 2022, there have been district court decisions that were affirmed by the Second Circuit Court, granting early termination of supervised release. He then cites and describes 3 such examples, Figueroa Flores, Ortiz, and Amato. But as far as the court can tell, none of these cases exist.
Whoops!
Now, in light of the foregoing...
Oh no! Oh no! You mean they literally just made them up? Someone did.
The court says Mr. Schwartz and Mr. Cohen, no later than December 19th, shall provide copies of the 3 cited decisions to the court. So I don't know where they're going to get them. Now, if he's unable to do so, then Mr. Schwartz shall cause in writing why he should not be sanctioned pursuant to the rules of civil procedure.
Yeah, it actually went even further. It went even further than that. I mean, it was a clip that he had to cut down for time purposes. So I understand why he didn't give the entire length of that order, but also said that the court was demanding to know what level of involvement, if any, Michael Cohen himself had in preparation of that letter. Because what is apparent is this, and I shared my own personal story on Twitter. I'll share it with you here now for those of you who are not hardy enough to drift into the perils of social media, known as Twitter or X, and that is that I this year had an incident for my own legal research cases unrelated to this show. I had to engage in legal research, and there was a particular issue that I wanted to find, and I wanted to see, on this issue of law, what is the rule of law? And I'm pretty sure I used ChatGPT. I was like, why would I just start there? And I started there, and they gave me these quotes and these different case citations. Give me 5 cases. I was like, all right, cha-ching. This is beautiful. This is awesome. And when normally when I do research, like I'll sort of do that weeks in advance of when I have a filing done, and then I'll start getting down to writing and putting everything together over the final week. So I sit down to writing. I'm like, all right, let me pull up my research here. So I had those little clips and those citations. I started looking for these. I was like, these citations, let's see the context of the cases, how strong they are. I start pulling up these cases. I look at the first citation. No such thing. It's like, I was like, what? There's no case. It's like literally like the case, no case. I was like, maybe the citation is wrong. I start searching through like different things. I'm like, maybe there was just like an error. A number was transposed. I start Googling like all over in New York whether this case ever like happened. No. Second case, same thing. Third case, same thing. The fourth case actually existed, and it was like a 2-line denial of certiorari from that like they applied to the Supreme Court, and it was a case. I don't even know what the case had anything to do with. It was an actual citation. I'm like, what the hell am I looking at here? And like the last case had something to do with like criminal law, like search and seizure. Nothing at all to do with my with the civil matter that I was handling. Like not even like remotely related. And I was cursing like Elon. You literally, it was like as if I said, in fantasy land, what would be some citations I could use if I wanted the law to say X? Apparently that's how ChatGPT read my query. I was so angry because I was like, oh my gosh, I gotta start doing legal research. I don't even know what the law is on this thing. I thought the law's on my side here. I was all excited, everything is good. Turns out the law on that particular issue was not really favorable to me. It was almost like, look, Joe, unfortunately, you kind of lose on this issue. But if the law was on your side, here's a list of cases that may have happened that would have said things that you wanted them to say. I'm like, oh my God, this is so terrible. This is so terrible. I was scrambling like a lunatic. I was so angry. So I learned from that. Never, ever, 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 ever trust Chat GPT. And if you might want to use it. You might want to use it like as a preliminary thing. Maybe sometimes you'll find something. I noticed that in response to my post there that that Andrew Branca said that he finds AI to be like 70% accurate, which is much better than the numbers I got. But yeah, it was really, really bad. So, but what I realized is that part of that order, as referenced by Robert Gouvet in that little clip, is that they had to respond by December 19th. And in case you haven't realized it, because you're busy like with life and stuff like that, you might not realize this, but December 19th was yesterday. So I was like, before the show, I'm like, I wonder what they said. What did they write back? They had to write something. What did they write? What happened? Let me pull up this case. You probably want to know what the hell happened. I haven't seen anyone talking about what happened. So here's your follow-up, because everyone needs some follow-up. This is the actual docket as listed by courtlistener.com. Right here is the docket for Michael Cohen's case. Over here you see the order to show cause. And in court order. So, right. And here, order as to Michael Cohen. So this was filed actually not just yesterday, but 2 days ago. So if we download this here, let's see what we got. Jesse Furman, December 12th, court entered an order to show cause directing David M. Schwartz, counsel of record. counsel of record for defendant Michael Cohen to explain why he should not be sanctioned for citing in defendant's latest motion for early termination of supervised release cases that appear not to exist. I can only imagine the cold chill that's running down the attorney as he's just drafting this response. On December 15, 2023, it was 3 days later, Schwartz, through counsel of his own, filed a response to the court's order show cause accompanied by a letter motion to seal his response. So please don't let people make fun of me. Please seal my response. In the letter motion, counsel opined that Schwartz's response to order show cause implicates the confidentiality of the attorney-client privilege. So maybe Michael Cohen was involved here. But that under the unique circumstances present here, the New York rules of professional conduct permit, indeed require, disclosure of those communications to the court. See, you might not be familiar with the lawyer jargon, but what's being implied here is this. There was certain communications between me, the attorney, Mr. Schwartz, and Michael Cohen, the client, which led to me putting that filing in there in the form and with information that the court found objectionable. So I'm doing what my client directs me to do, but I can't really this attorney-client privilege, he's entitled to that privilege that if he has communications with me, I'm not allowed to just go blabbing about, blah, 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 wherever I want because he's protected by attorney-client privilege. But I don't want to have my neck in a noose here when there's certain bases here related to actions done by Michael Cohen, the one who's constantly killing Trump for his lack of integrity, the guy who perjured himself before Congress. That Michael Cohen apparently had some communications that left his lawyer in a position that he's like, I don't think I'm supposed to bear the brunt of this one completely on my own, at least, if at all. So the letter motion requests that Schwartz's submission be maintained under seal until the court resolves whether Mr. Schwartz can reveal the information stated in his affirmation without violating attorney-client privilege. So I sort of need direction from the court. I have to tell the court what it is. Whenever you file anything, it's going to be a public record, and I'm urging you to, I'm afraid that maybe my opinion is that this is an exception to attorney-client privilege, and I'll come tell you this. But what if I'm wrong? If I'm wrong, now because I'm filing as a public record, I might be violating attorney-client privilege. The way to help insulate me from that is that I'll share with the court in camera, in private, in confidence, exactly what happened. And then the court can basically come back and say whether this is something that I'm allowed to share publicly or not. Because, let the court, that way it's not my neck in a noose for breaching my rules of ethics under the rules of professional responsibility. So I'm asking the court to sort of weigh in and let me know what they want me to do. The letter motion is to seal is granted on a temporary basis. Given that the issues implicate defendant, court will give him through E. Daniel Perry, who entered notice of appearance on behalf of the government after the government filed its opposition, meaning he got a brand new lawyer now. I'm on my way out of here. I am distancing myself from Michael Cohen. Like the dude has scurvy multiplied by leprosy, multiplied by AIDS, with a little dash of Ebola in there. That whole Ebola thing, that's what really put me over the edge. And then filed a reply which disclosed that the case decided in the original motion could not be verified. An opportunity to be heard. In light of the upcoming holidays, defendant shall file any response by December 28, 2023. Meaning, come on, it's Christmas. Let's not make me crazy here. Schwartz may in turn file a response to any submission by defendant no later than January 3rd, 2024. So what we're about to see happen here, and now the court's demanding some sort of explanation as to why it is that you're relying on ChatGPT instead of the old school books like you saw in any good 1980s law TV show, instead of all them books, or at least some online research like they taught us in law school in the 90s. So that as far as this new reliance on this newfangled ChatGPT, artificial intelligence, and artificial in big letters and intelligence in quotations. So, but what this has led to is some finger pointing, where Michael Cohen's gonna be like, it's on you, and David Schwartz gonna be on you. And eventually, this probably will become public fodder. We probably are going to find out more about this entire thing, but there's going to be this little back and forth exchange that'll be happening sometime over the holiday season. So happy holidays to you. Happy holidays. Defendant's response should address the substance of Schwartz's filing, whether Schwartz disclosed the court violated the attorney-client privilege, and relatedly, whether Schwartz's filing and defendant's response to it should remain under seal or be docketed either in redacted or unredacted form in the absence of submission by the defendant by December 28th. That's Cohen himself. Schwartz's submission will be unsealed without further notice to the parties. So, yeah. If you don't want us to unseal this and you think there's some reason for this to remain sealed, you got to put your response into to what Schwartz said about you, Michael Cohen, and what explanations you have for why this remains sealed. Because you need to limited bases as to why someone should be able to have something sealed, and this doesn't seem like it's probably going to conform with it. Although counsel Schwartz state that they appear only for limited purpose of response to the court's order shall cause, they shall promptly enter a notice of appearance no later than December 19th. And that's what we saw that they did. If you looked at this thing here, the following follow-up is they have their little notice of appearance. So there you go. Here are your little notices of appearances. And blah, blah, blah. So that is your update. Very exciting stuff happening in the world of Michael Cohen. And those of us who enjoy following that blowhard, because I sure as heck am one of them. Because dude it's like almost like if Chris Christie and some mob boss had a baby, that would be Michael Cohen right there. Let's give him some nice Jewish name. Well, anyway. What do you mean I'm banned? What does that mean? Where am I banned from? Where am I banned from? I only notice you because the Archer icon, okay? Archer. All right. So that's the story there. Time for us to get to the issue of the day. The issue of the day is this. Page 25. Go to page 10. We're not going to read through this entire brief that was prepared by Donald Trump's attorneys. But there was a brief that was filed in court today. You may recall last week we talked about how Jack Smith decided that he wanted to go bypass the appellate court, go running to the Supreme Court. And we covered his application to the court saying, hey, look, I just won in front of Judge Chutkin. Trump is appealing that. I want to jump straight to the Supreme Court. These are good questions. I can't answer that. I can't answer just because here's the thing. It probably is that Mr. Schwartz there is a far more ethical attorney than Mr. Cohen was. That's likely the case. Oh, let's face it, it'd be hard for him to sink much lower, right? It's got to be really, really hard. So just because your client may be a scumbag or has been proven to be a scumbag, or rather than just may being, well, you got what I'm saying, a scumbag, that his counsel may not exactly be that gross level of grossness. Probably. So he's like, I'm not going to fall into that. Well, thank you, Frankie. Thank you so very much. I don't actually celebrate Christmas. That's true. That's part of the whole Jew contract. There's a whole list of stuff that they make us sign. So one of them is I don't get to celebrate Christmas, but I'm very happy to wish it to you guys, and I really hope that you I genuinely hope that you have a phenomenal Christmas, better than ever. I like people being happy, and if they're happy in their worship of their faith, all the better. All the better. Hindsight is like foresight, but more finger pointy. Yes, a lot more finger pointy. It's gonna be like this is gonna be like this is gonna be like Dr. Phil multiplied by Jerry Springer, but like in front of like Judge Judy. That's what we're basically having here. If Judge Judy was a federal district court judge. Sorry, I didn't mean to disparage a federal district court judge like that. It was obviously far more prestigious than Judge Judy. Probably a lot less financially successful. All right. So Jack Smith ran to court and he said basically, he's like, look, I know I need permission to come before you. So I'm asking for permission to come before you. And not just that we should come before you and that we should bypass the appellate court, but that you should do that and do it on an expedited basis. So I don't really have a right to come here. I don't really have that whole legal right. I'm kind of violating like a dozen protocols in coming to you in the first place at all. But I'm not just coming here and saying you really need to hear our case, because ultimately you're going to need to hear our case anyway. But also, you got to do it fast. I don't want to hear none of this Christmas vacation stuff for you folks. I don't want to hear about that. Is that Jewish contract legally binding? Did you send me your address? I haven't even looked in that email. Did you send me your address? Because I know I owe you a hat. Even though I didn't think that you were gonna, the only guess was gonna be the right one. It's like, man, you suck. Hold on a second. Yeah, health thing. I know you're all wondering what I do whenever I like turn my camera and mic and say health thing. And you probably assume that like Nancy Pelosi, I'm injecting Botox into my face before it slides down into my chest. It's not exactly that. Just figuring I'm sparing you all the gross fluids that are emitting from my body as I'm trying to finish recovery from this ailment. So that's what's happening. That's what's basically happening there. Okay. So Jack Smith goes running in Supreme Court. He says to him, hey, I know I'm not supposed to be here. I actually won at the lower level, which makes it even weirder for me to be appealing. And I know that there's been an appeal that was filed in the DC Circuit Court by Donald Trump, who lost in this motion before Chutkan, that had this whole issue about presidential immunity. And whoever loses before the appellate court is ultimately going to come here. And this is an issue of first impression. So you really need to take this case. Oh, and while you're taking it, do it really, really fast. I don't want to see you lollygagging. I know how you like to lollygag there, Clarence Thomas. I don't want to hear that. I don't want to see you being all lazy, Alito. Yeah. Anyway, so that's essentially what he was asking for. Court directed Trump to put in their response to the application that was made by Jack Smith by December 20th, which happens to be today. If you got my post on, if you got notification of the stream by the post on YouTube, so I said 12/20, happy birthday, Sandy, and then explain, and then just introduce the post. And you're probably all wondering, who the heck is Sandy? You're probably wondering that. So I'm going to tell you right now that Sandy is a friend of mine. In fact, the first friend I ever had in my life. The first real person friend. As opposed to the myriad of imaginary friends that I had during the first 5 years of my life, which definitely don't need any counseling at all. But he was my first real friend who I met when I was 6 years old and spent the next like 12 years of my life in school with. And his birthday is December 20th. So, and for one reason or another, I can't explain why, I always remember his birthday. I never wish him happy birthday. Like, I seriously, I think like 3 times in the last 30 years. I still know him today. I see him. He lives in my community. I see him around time to time. Not that we're nearly the same level of friendship that we had then, but I still consider him a friend. So I always remember his birthday. So that's why I was like, I never tell it to him directly. But I'm like, oh, it's December 20th, Sandy's birthday. Probably because it's like the first friend's birthday who like I ever like, oh, that's my friend's birthday. So maybe that's why it's just etched in my brain, and likely will be for however long my mind is cogent. So yeah, Sandy's man. It's actually short for Sanford. So there you go. So that's Sandy. So happy birthday, Sandy. If you ever see this, which the chances of that happening are actually fairly limited. All right, let's get back to the matter at hand. Here is the response. And we're not going to just read through this response. I actually prepared notes. You'll see. You'll see. It's coming. It's coming. This case presents, this is the response from Trump's team to Jack Smith's request for expedited review by the Supreme Court. And the Supreme Court, by the way, they're not deciding this case at this stage. They're simply deciding whether or not they're going to decide this case at this juncture. That's really what this is about. So this is not like a full fleshing out of everything, but it's a fairly strong synopsis. It's a fairly strong synopsis of where things are going. But it's not, the court here is not going to be deciding, yes, there's presidential immunity. No, there's no presidential immunity, at least not at this stage. They're simply at first going to be deciding, yes, we are taking this case, or no, we're not taking this case. And if it's yes, we are taking this case, yes, we're doing it on an expedited basis, or no, go jump in a lake, and we'll take however damn long we please to do this. So that's the stage we're at now. I don't want people to be, I think a lot of people are likely confused about the status because like it was accepted by the court. It was not accepted. The court has entertained the petition for certiorari sufficiently to say this is how we're going to examine this right now. So here's Trump's take on it. What do you think? Trump wants them to take it? You think Trump wants them to take the case? Think Trump wants them to take the case? What do you think? What do you think? What do you think? Put 1 in the chat if you think yes. 2 if you think no. I'm looking at you, Rumble folks. Put 1 in the chat if you think that Trump wants him to take the case. 2 if he's saying no, you don't need to take the case. I'm seeing some ones. Only a handful. All right, 265 of you watching. I'm all the way up to 47 likes. All right, a couple of 2s, but most of you saying 1. Let me see over here. Oh, it's much more 50-50 over here. Much more 50-50. All right. So, introduction. This case presents a fundamental question at the heart of our democracy. You're going to see, by the way, Trump's team does not want them to take the case. Nope. Do not touch this. And make strong, compelling arguments as to why the hell are we here? Like, why are we even being forced to respond to this? Because this makes 0 sense how it is we're in the Supreme Court. And they make some really strong procedural arguments as to where Jack Smith has some audacious cojones for even making this request. This case presents a fundamental question of the heart of democracy. Whether a president may be criminally prosecuted for his official acts. Oh, actually, we should go back before this. I'm going to go back before this. Something before this I wanted to share with you. I think, if I recall. Was I mistaken? Yeah, question presented. This is what I wanted to look at. You always start with the question presented. Now, whoever's making the petition is going to form the nature of the question in a way that they feel is most tailored toward benefiting a decision in their favor, even if it's not exactly what the question is. This is something that you learn a lot, is the answer that you get will often depend on the way you frame your question. How you frame a question will often go a long way, and this is something attorneys understand very well, very well. And this is why we're very precise, particularly those of us who practice litigation, very precise in our questioning, because the nature of the question will dictate more often than not the answer. So you need to spell out what questions are presented for the court to address. And what they point out here is petitioner's proposed question presented misstates the legal issue in this appeal by incorrectly framing it as whether absolute presidential immunity extends to crimes committed while in office. That's how they word it. Is there absolute presidential immunity for any crimes committed in office? But in the district courts, that's not what they were talking about. Respondents asserted that a president's immune from prosecution for official acts. We're not saying he's never prosecutable, but when it comes to official acts, that's what we were talking about. And if they want to appeal, they have to appeal from what we said and what we lost on. Because this is what we said. We told Judge Chutkin that there's presidential immunity for any of his official acts. Not like if he just walks into a bathroom and is like, "Oh, I don't like you. I'm gonna shoot you in the face," and then does his business and leaves. And there's no cognizable function towards serving the Constitution, United States of America's interests, that he's immune. But if it's something that's clear, that is within his official acts, that he is immune. So the questions presented there thus are whether the doctrine of absolute presidential immunity includes immunity from criminal prosecution for president's official acts, i.e. those performed within the outer perimeter of his official responsibility. And I want you to focus on this, because this is something I'm going to spend a lot of time talking about tonight. The outer perimeter of his official responsibility. And this is to me, I'm telling you right now, I'll tell you this much. Those of us who are confident that he's going to be deemed immune, which I consider myself in that camp, I am going to tell you this. The biggest struggle is making sure these acts actually qualify as if they are within the outer perimeter of his official acts. Because then you have to ask yourself, what does that mean? What are official acts? Is anything he does towards presidential type of activity, the outer perimeter, if it's not his job, let's say, here, I'll give you an example of something totally unrelated to Trump, okay? Totally unrelated to Trump, okay? If he's promoting, let's say our armed forces. That's not good. That's a poor example. Let me come up with a better example. Okay, here's a great one. If a president is advocating for people to engage in using solar power, is that part of his? It's like, and he basically makes a commercial saying, "I think people should use solar power." Is that part of his official acts? What duties of the president relate to climate change? Is that even part of his duties? Like, is that part of his responsibilities? The responsibilities aren't like part of the economy. It's not part of like taking care of the climate. Arguably, perhaps somehow it's tied in. You see relationships to it. That's not part of his. If you look at his official duties, is that part of it? You can make a claim saying it's related to environment, and he's supposed to be executive branch and supposed to be overseeing it, whatever. But it's like solar panels, like that's part of his duty. Is that part of his official duties? Yeah, okay. If it's his activities if it's his actions where he basically says, we're going to drop an airstrike, like Obama, and this is going to come up shortly, like Obama drops an airstrike. Total F up. Total screw up. Okay? Complete screw up. But that's clearly within, like, he's supposed to be handling our foreign relations. I mean, that's totally within his presidential duties. George Bush lies about WMDs. You can have all sorts of issues with that, and we'll talk about that shortly too. But this is definitely part of his function as far as overseeing foreign affairs. Now, you can have issues with the way he handled it and say that he's corrupt and he did all sorts of illegal things, or terrible, incompetent, whatever it is. But that's where you would say, okay, he's definitely working within his presidential duties. He might be doing a crap job. Might be doing a something, an impeachably terrible job. You can make those claims. But that doesn't mean it's not within his. If you figure out what's his official duties, it's definitely within the scope of his official duties. So where do you have that outer perimeter? It's a little bit more confusing, and I think that's where Trump is likeliest to struggle. But we'll come to that. We'll come to that later. And the second is whether the impeachment judgment clause and principles of double jeopardy foreclose the criminal prosecution of a president who has been impeached and acquitted by the U.S. Senate for the same and/or closely related conduct that underlies criminal charges. So those are two questions presented. Now, what they do, when he's writing this, what he does next is he comes into, in his introduction here, it says this case presents a fundamental question at the heart of democracy and whether they can be criminally prosecuted for those official acts. In 234 years of American history, no president ever faced criminal prosecution. Until 19 days ago, no court has ever addressed whether immunity from such prosecution exists. Judge Chutkan is the first judge ever to weigh in and say there's no presidential immunity. But there's no other decision we're going to find on that issue. To this day, no appellate court has addressed it. We've never heard from a single appellate judge as to whether or not there's presidential immunity for acts that were committed or within the outer perimeter of your duties as president, whether there can be criminality. And it stands amongst the most complex, intricate, and momentous issues the court will be called outside. Ordinary review procedures will allow the D.C. Circuit Court to address this appeal, meaning you don't have to go to this. The D.C. Circuit Court is going to address this. This first an appeal that we filed there, and the D.C. Circuit Court is going to be addressing this. Now, and the benefit, that will grant this court, what's the benefit of that? Why should you let it go there first? That will grant this court the benefit of appellate court's prior consideration. And that way the court will do the traditional winnowing function that this court has long preferred. Because if the court basically is able to carve out certain parts of it, it makes this court can really zone in on the nugget of law that's really essential, because there's a little bit of murky areas as to like what's legislative and what parts are really beyond question, and what parts are more have and frame out what the court on the lower level thinks about things, not just one stinking district court judge Chutkan. Indeed, the Circuit Court has already granted highly expedited review of President Trump's appeal, so it's already going to go through them pretty quickly. And over the opposition, with briefing to conclude by January 2nd, and oral argument scheduled for January 9th, which is lightning fast. Lightning fast. Normally, these things take many months or years in the Circuit Court level, but they're jumping through hoops to get it going through there. Special counsel urges this court to bypass those ordinary procedures, including longstanding preference for prior consideration, and rush to decide this issue with reckless abandon. The court should have declined that invitation at this time for several reasons. What are these reasons? Why is it that we're telling you should say Jack Smith, you're way out of line here? Number one is that the government lacks Article 3 and prudential standing to appeal. What's an appeal? Why does someone ever appeal? The reason you appeal is because you lost. That's what you're appealing from. Who the hell wins in front of a court and says, I know, hey, I just won. Let me go appeal that decision, which is exactly what Jack Smith is doing here. He won completely at the lower level. if the winner, you're not injured. If you're not injured, there's nothing for you to appeal for help from the higher courts. You're appealing that you have been punished. You lost out on something. But he lost out on nothing. He won everything, and he's trying to appeal. And they cite Camerata versus Green. He said, because the government is not injured by the decision below, meaning Judge Chutkan's decision, this case does not fall within the narrow class of cases where the court has permitted a prevailing party to appeal from a lower court victory. So that's the first problem you got here. What are they required Times New Roman? I think it's really crystal clear. It's really just clear. Other courts allow Arial. Other courts allow Arial. But yeah. But most courts, I always use Times New Roman on all my legal documents because I'm just like, I know that's definitely going to be okay. I never have to worry about being okay. Second, prudential considerations weigh heavily in favor of allowing the DC Circuit Courts to address the issues in this case before the court, consistent with the court's ordinary review procedures. In fact, such lower court consideration is rapidly underway. So he's going to get into the prudential considerations later on. Third, special counsel identifies no compelling reason for the extraordinary haste he proposes. You don't tell us why. It's like, this is really important, so do it fast. Why? Why do we need it fast? Yeah, it's important, but why fast? Why do we need a quick decision? Where does that come from? Instead, what does he do? He vaguely asserts that the public interest favors resolution on a dramatically accelerated timetable to ensure that Trump may be brought to trial in the next few months. Why? Say it. Say it. Say it. Why? Why? What's the problem? Like, how is there a problem here? In doing so, it confuses public interest with the manifest partisan interest in ensuring that President Trump will be subjected to a months-long criminal trial at the height of a presidential campaign where he is the leading candidate and the only serious opponent of the current administration. So Jack Smith's working for the current administration. He's like, oh, no. We have to get this going against the most serious opponent that Biden faces. We have to do this now during that's why? Why do we have to do this? Why is it so urgent? The combination of an almost 3-year wait to bring the case and the special counsel's current demand for extraordinary expedition supported by the vaguest of justification creates a compelling inference of partisan motivation. They could have brought this in 2021, 2022. I mean, they waited 3 years, and now they're like, oh, now that we waited 3 years, now we have to get it done before what? Before what? It seems like it was clearly designed that this trial and this whole process is going to happen during the heart of a presidential campaign. Fourth, his case law. The case law special request cites does not support his request. United States versus Nixon. Court did not face the same historically blank slate that it confronts here. In Nixon, there had been extensive, thoughtful consideration of presidential privilege applied to criminal subpoenas, including multiple appellate decisions over nearly 2 centuries between United States versus B. Burr and Nixon versus Sirica. Here, the sum total of judicial grappling with this issue. So that was a whole issue about subpoenas, where they're trying to rush through stuff over there. There was all sorts of case law related to that issue. Here, all you have is one 19-day-old district court opinion. There's nothing that's relevant to this. And the history counsels in favor of allowing D.C. Circuit Court to address this appeal first in the ordinary course. Fifth, the district court's ruling below was issued 9 days after the close of briefing due to special counsel's insistence of a speedy resolution. So we already rushed to get this far. Well, the only reason we got the decision as fast as we did is because Judge Chutkan was rushed. So why the heck is Jack Smith running everything through? And the result of her haste was that it overlooks binding authority and commits manifold errors. She made mistakes, and the point that he's making here is she made mistakes because we rushed. That's why we have this erronious decision in the first place. because he's been pushing, rush. We have to do this now. Oh my God. That's what Judge Jackson's been doing. He's like so urgent. Everything has been done yesterday. This appeal presents momentous, historic questions. An erroneous denial of a claim of presidential immunity from criminal prosecution unquestionably warrants this court's review. Meaning, if circuit court denies us, yeah, we're definitely going to need your review at that point. Don't think that we never want your review. If they make an erroneous decision and deny our appeal at the circuit court, which, let's face it, between you and me, chances are very high they're going to deny Trump's appeal because it's DC Circuit Court. The special counsel, in that case, we're going to need your review at that point. But the special counsel contends that it is imperative public importance that respondents' claims of immunity be resolved by this court. That does not entail, however, that the court should take the case before the lower courts complete the review. Yeah, maybe ultimately it will be yours, but that doesn't mean that you shouldn't let the lower courts do what they do. Every jurisdictional and prudential consideration calls this court to allow the appeal to proceed first in the DC Circuit Court. Haste makes waste is an old adage. It survived because it's right so often. Quoting the Seventh Circuit. So, now he makes the point as to why this court lacks jurisdiction to act. The court is not even allowed to hear this case, as Trump argues. So, from an Article 3 perspective about prudential standing to appeal from a judgment that is entirely favorable to it, you cannot appeal if you win. Government seeks direct appellate review of a district court decision that granted it against all the relief it sought and did not rule against it on any issue. Sometimes you'll have that you win on some issues, you lose on other issues. We saw this in Trump versus Colorado that we were analyzing yesterday. At the district court level, she said Trump had engaged in insurrection, that this was an insurrection, engaged in insurrection. So Trump lost on that. But she also said that at the district court level that she didn't feel that Article 3 of the 14th Amendment had any bearing on a president. So he wins on that. So in that decision issued by the district court, each side won on part and lost on part, which is why they both ended up appealing. They ended up appealing the parts that they lost. Here, the court didn't lose anything. They won. The government didn't lose on any part of it. They won completely. When the court grants certiorari before judgment, it effectively stands in the shoes of the Court of Appeals. So, a party seeking certiorari before judgment to review a district court decision, therefore, must have standing to appeal a decision in the Court of Appeals. So, if you're going to step in here, just like the DC Circuit Court could not have taken an appeal from Smith, you're standing now in their shoes. And you too are not allowed to take an appeal from Smith because Smith won everywhere. And just like the circuit court would be prohibited if let's say he's like, I know I won at the district court level, but I really want to have a stronger court come out there and slam Trump. Let's say Trump didn't want to appeal it. And only Smith wanted to appeal at the circuit court level. Would he have that right? No, he would not have that right. He'd be like, hey, I want this to stand up, not just at this DC circuit case. And here's a reason he might have wanted to done that. Let's just think about this for a second. Let's assume that Trump said, I don't want to fight this on this issue. I don't really like the presidential immunity claim, which would be legal malpractice. But put that aside for a moment. Let's say Trump didn't fight it. Would Jack Smith have been allowed to go to the DC Circuit Court and say, I won completely in front of Judge Chutkan. I want to have this be issued by the Circuit Court. I want to appeal it so you'll affirm what the lower court said. And this way, we can take this decision and it'll be far more influential in front of in Georgia, where the same issue may come up. Would he have that right? The answer is obviously no, because an appellate court can only redress claims that you were wronged at the lower level. And if you won completely, there's nothing for you to claim that you were wronged about. When the Supreme Court has an application for writ of certiorari, they are stepping into the shoes of the circuit courts. So just like the circuit court would have had to reject that appeal, so too you, Supreme Court, are obligated to reject that appeal. Here, the government, which prevailed on every disputed issue below, could not have filed its own appeal in the DC Circuit Court, and the government suffers no injury from the district court's decision, lacks standing to appeal. In rare instances, the court may grant a petition review from a prevailing party. Sometimes you can win and still appeal, but that's only if the victor suffered an ongoing, traceable, redressable injury. So maybe sometimes you win, but it's not good enough because you need to have some sort of extra statement. There has to be some sort of injury that you're suffering that's redressable, that if the appellate court comes in, that will spare me from this particular injury. And they cite several cases for that notion. The party retains a stake in the appeal satisfying the requirements of Article 3. But this court's cases demand the prevailing party who appeals must suffer ongoing injury, causation, and redressability from the challenge decision. When a prevailing party's standing to appeal a favorable decision has been recognized, the ruling against challenge and appeal decided a significant issue against the party in a way that inflicted ongoing injury to the party. So even though I got a complete win, but there's one issue that they sort of left me out that I lost on that I kind of need to have that part appealed. So an official whose conduct is deemed unconstitutional but is granted qualified immunity though prevailing on the merits suffers an ongoing injury from the decision, a de facto restriction. Meaning it just, even though I have a legal win, it's not really completely helping me as far as how this is going to manifest. So in that, from your freedom to engage in such conduct in the future. So likewise, a class action, plaintiffs who have a nominal judgment in their favor entered against their will have still standing to appeal from an order denying class certification. Because that denial deserves them a significant procedural right. Meaning, let's say I file a class action suit. I say all of these coffee mugs that claim that they hold 24 ounces only hold 20 ounces. And I go and I sue the company and I file a class action suit. And I say, hey, you claim that this is 24 ounces, but it only holds 20 ounces, you sons of guns. So now, in that particular circumstance, and I try and get class certification. So in that case, the court might say, yeah, you have a real claim there. But for one reason or another, we don't think you have class action. So me as a litigant, I'm getting the same relief whether or not I'm certified as a class. So can I appeal that? Because really when they deny the class, it means all the other people who are similarly situated to me, who suffered the exact same wrong as me, that they are not going to be able to come forward. Do I have a right to appeal? If I appeal it, the cup manufacturing company is going to come along and say, well, he's still allowed to proceed with his claim. So he lost on class certification, but his issue, he can sue to get back his extra 40 cents on that. So he's saying there's a de facto damage to me because if I'm not certified as a class, even though there's other people winning, I'm not going to have any money for this lawsuit. So yeah, I won the issue that I can go forward with my claim and get back my extra 40 cents that they owed me, but that's not really helping me. So that's a circumstance where I might get a win, but the de facto of lose the parts that I lost on, even though the part I lost on isn't directly hurting me, it's manifestly going to end up affecting my ability to process my claim. So anyway, bottom line is not so here. District Court denied President Trump's claims in toto, wrongfully holding that there's no presidential immunity from. We think that she was wrong, but we still lost completely. District Court did not rule against government in any disputed issue. So they don't have any prospective effect of an adverse nature against the government. Everything here was win-win. Everything was gravy for the government. What the heck are they appealing from? The only injury the special counsel asserts, what is their injury? Is a possible delay of the trial date. Oh. Even if it's cognizable at all, it's not caused by the district court's decision. It's not their decision. It's the fact that we're appealing that's causing it. But it's not their decision that's causing that issue. This is a great argument. This is a great argument by his counsel. Instead, the government contends this court's rulings in Griggs and Coinbase, which requires stay proceedings pending appeal, are inconvenient or therefore harmful. The government may be injured by President Trump's appeal, but it's not injured by the district court's judgment. Yeah, it hurts them that we're filing the appeal, because we didn't file appeal, there'd be no stay. But that's not part of, that's not what you're appealing from. You're appealing the actual decision, and thus it cannot file its own appeal from that judgment. Moreover, even if the court had jurisdiction to grant petition, which it doesn't, you shouldn't exercise it here on the longstanding rules of potential standing. Ordinarily, only a party aggrieved by a judgment or order of a district court may exercise statutory right to appeal therefrom. Okay. The special counsel's bare political desire to have an earlier potential trial date does not place this case in a special category when it comes to this court's review of appeals brought by winners. Yeah, sometimes winners can bring an appeal, but the fact that you want to have they have a political motivation that, hey, we really want to get this done before the election, like have this whole trial happening during election season. That's not a special, that's not any kind of a special category. There's when we go, let me go rifling here through my list of special categories here. Let me see if there's political ambition to screw up the other guy's campaign. No, that's not it. No. Here's potential injury of body, potential financial losses. Where here is that so I can screw over my political adversary? I don't see that here on the list here anywhere. So the special counsel ignores this issue in his jurisdictional statement, an omission that illustrates the hazards of expedited briefing. This is such great writing. What's he saying? He's like, we shouldn't work too fast. And you shouldn't just rush to work too fast because it's going to lead to error. And this issue that you need to have a special category in order to have this, that's something that the special counsel, meaning Jack Smith, left out in his papers. He should have told you about that, but he left it out. You know why he left it out? You know why he probably left it out? I don't think it's because he was hiding the ball. I don't think that he was trying to do anything illicit. He was sloppy because he had to work too fast. That's part of the problem with working too fast. That's his omission, his failure to inform you of that is precisely what shows you some of the hazards of having an expedited briefing. His jurisdictional statement merely cites Biden v. Nebraska and United States v. Nixon with a parenthetical note that in each certiorari before judgment was granted to the party that prevailed in district court. But neither case addressed the prevailing party's Article 3 of prudential standing to appeal from a victorious ruling in the trial court. Drive-by jurisdictional rulings of this sort have no precedential effect. Indeed, Camerata and Roper post-date Nixon. They happen after Nixon. But neither case discussed Nixon in analyzing appellate standing because it's got nothing to do with appellate standing. Moreover, in Nebraska, the state respondents did not oppose the government's request for certiorari before judgment, which was embedded in an application to vacate the Eighth Circuit's nationwide injunction pending appeal. So the issue was never raised or discussed by the parties in the courts. All right. So, accordingly, in short, the special counsel cites no case supporting the government's appellate standing here. Tam says California Lieutenant Governor Eleni Kounalakis is now trying to get Trump taken off from the ballot. Yep, we knew that was going to come. If the Supreme Court rules against Colorado, will that negate all other states from removing Trump from the ballot? Almost certainly. Almost certainly. Yes. Can't tell you how the wording of the order would be, but it seems difficult to conceive of a situation that they'll overturn Colorado and enable some other state to make the same mistake as Colorado. That would be self-defeating. What's the most effective way to complain about pro-Gaza ads on your stream? Team YouTube or X or something else? Really? I have pro-Gaza ads? That's gross. That's disturbing. That's really, really sick. I appreciate you giving me the heads up on that. I'm going to make a note about that. It's 59:18. Okay. Thank you for calling my attention to that. Lower East Side Commie says, Lower East Side Commie. I don't have to read any further. I'm not even reading this. I think we all agree that Colorado means great things for our party and country. Looking forward to winning bigly now that Nikki will be our nominee. That will never, ever, 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 ever happen. You freaking Lower East Side commie. Never, ever, ever. Never. Never. Oh my God. Should start World War III. Should really be a disaster. I'd rather have Biden as president than Nikki Haley. I'm not even saying that facetiously. I would rather have Biden. I'd probably vote RFK, but appeals are for losers only. Yeah, see that he should have heard from Branca. Jack Smith had to hear from Branca. Section 5 of 14th Amendment, USC rebellion and insurrection, Coffin v. U.S. 1895, presumption of innocence. Trump must be convicted to be barred. Godspeed. That's a wonderful case. I actually spent a long time reading this afternoon through the dissent in the Colorado case, which I thought made some, first of all, turned some phrases that just blew my mind. But like blistering lacuna. Oh my God, I was like, blistering lacuna? But also some legal insight that was really profound. Really profound. I was like, I really want to go through this on Locals or something, because I can't spend another hour and a half doing that on my regular stream. Can SCOTUS basically step in as finder of fact given the absurdity of defining J6 as insurrection, i.e. just say, nah, it wasn't insurrection, or the easiest sidestep to just say double jeopardy? It's unlikely that they will do that, because a technical definition of J6, of whether or not J6, I don't think we will ever hear SCOTUS determine that it was not insurrection. I don't think we're ever going to hear that, because that is a fact-finding issue. So I don't expect that to happen. So what is an insurrection? I mean, to me, an insurrection is something that's organized and designed to overturn governance. Then, I have to be fair and recognize that, like, okay, so what's rebellion then? Which is worse than insurrection. So insurrection has to be less than rebellion. So I don't think that this is enough. I don't think insurrection can be spontaneous. To me, that doesn't make any sense. Which is one of the reasons I don't think you can incite insurrection. I think the phrase incite insurrection is kind of, I think there has to be, you can incite a riot. I don't think you can incite an insurrection. To me, that phrase isn't English. It's like saying you're inciting a play. You're inciting a movie. Like, there's too much. No, that can't be. How do you do that? You know what I'm saying? Like, I don't. That doesn't make any sense to me. I would look at insurrection perhaps as maybe a rebellion of a state, like against a state rather than the entire country. That's how I probably would look at an insurrection. I don't know. I was listening to Scott Gessler argue about what's the difference between those three terms: a riot, an insurrection, and a rebellion. Or revolt is another term, which is also seems more closer to rebellion. I don't know. All right. On August 1st, 2023, we're about to get to our lecture. I told you there's going to be a class here, and this class is now in session. All right. So let's just I lost my ding. It's not here. That stinks. All right, that was it. Class is in session. No, that didn't work. In my brain, I heard ding. All right. On August 1st, 2023, so President Trump was indicted on 4 counts related to his attempts to dispute the outcome of the 2020 presidential election. And the indictment does not charge President Trump with responsibility for the events of the Capitol on January 6th. So they don't say it's his fault. They say that his political speech and advocacy in disputing the election's outcome performed while President Trump was still in office. The indictment alleges that President Trump engaged in 5 types of conduct. First, says that he made a series of tweets and other public statements on matters of paramount federal concern. Okay, so that's the first thing, is some really mean tweets. Second, it says that he communicated with the acting AG and officials of the U.S. Department about investigating election crimes, which that seems like it's official acts. These include allegations of a series of communications urging that the AG investigate widespread fraud. Third, they say that the president communicated with state officials about and the federal election and urged them to exercise their official responsibilities in accordance with extensive information that the 2020 presidential election was widely tainted by fraud. The fourth thing that the indictment says is that Trump communicated with Pence in his capacity as president of the United States, as president of the Senate, vice president's official staff, and other members of the Congress to urge them to exercise their official duties with respect to election certification in accordance with Trump's contention that there was fraud. And finally, the indictment alleges that other individuals organized slates of alternate electors. And that's what they say he did. Those are the 5 things that they say he did, which we're calling that official acts. To us, that seems like it's official acts. So then he moves for double jeopardy. On base, he moves to move to dismiss because of immunity and double jeopardy. And he says that, first of all, there's absolute presidential immunity from civil liability for official acts extends to criminal prosecution as well. And second, there's double jeopardy. And second, that there's that anything that's within the outer perimeter of presidential duties, we cannot be charged with. On the first question, Trump offered a series of reasons to recognize presidential immunity. Now, I want to break down these reasons why we recognize presidential immunity, and this is kind of important. So I'm going to break down for you, why is it that we have presidential immunity? And they go through 7 reasons why it is that there's presidential immunity. Now, the next 4 or 5 pages get very convoluted. So what I did here was I actually prepared a PowerPoint, because everybody loves PowerPoint. I know you're lying and claiming you don't, but you love PowerPoint. So 7 points, 7 points that we can knock down succinctly what the 7 reasons are as to why there is presidential immunity for any acts that are taken there within the official ambit of what you've done. And this is what they say. Number 1, first point, separation of powers. You know why we have presidential immunity for any acts taken that are within the outer perimeter of what you do? So Nixon v. Fitzgerald, which is a Supreme Court decision going back to the 1960s, says that 1970s, is because, what year is it? 74? Says that the doctrine of presidential immunity is rooted in separation of powers under the Constitution. The president, and what did they say? They said the president occupies a unique position in the constitutional scheme. He alone, forget anyone else in the Constitution, that office is completely separate and distinct as set forward by our Constitution. And he has absolute immunity predicated on his official acts because he has these special duties and these special powers. So he has absolute immunity, and because of his functionally mandated incident of the president's unique office rooted in the constitutional tradition of separation of powers and supported by our history. I know you guys are back. Sorry about that. You guys are shocked that I actually did homework here, right? Doesn't this look so important? Doesn't it look so official? I did do a spreadsheet. I did a spreadsheet. And yes, there will be a test. Can I get a gold star? There's going to be a test. So the first point is separation of powers, which is basically, and it really can be brought down as simple. What do you got here? Boiling a frog. I don't know. Thank you. Thank you, Monkey Training. How much damage was happening before SCOTUS acts? Well, I think we're getting close. We're getting close to that limit there. But the point is this: because he has that special role as the head of the executive branch, ultimately, under separation of powers, you can't sit in judgment of him. How are you supposed to sit in judgment of him? Because that now is enabling the judicial branch to basically sit over him. Say, or a prosecutor trying to sit in judgment over a president's official acts when those acts are vested in him alone. If he alone has those powers, how is anyone supposed to come along after the fact and say, oh, we're going to judge whether or not you did it right? He alone has those powers. It makes no sense. As Chief Justice Marshall emphasized in Marbury v. Madison, I love the fact that he cited Marbury v. Madison because this is one of SCOTUS's favorite cases because it gave them such broad power. By the Constitution of the United States, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion. You know who he's accountable to? His country and his political character, meaning how they end up viewing him, and to his conscience. That's it. He's not accountable to a judge, to a jury. He's not accountable to some district attorney. That's what we said in Marbury v. Madison. That's the logic applied in Marbury v. Madison. The acts of such an officer as an officer can never be examinable by the courts. Boom. 1803. That's presidential immunity. It's pretty strong. So number one, why do we have this? Separation of powers. Number two, constitutional text. The Constitution itself, this is arguing, and it's feeding right into the likes of an Amy Coney Barrett, where they base and those anyone who's sitting on the right, where they basically they give a textualist argument and an originalist argument. When you're in law school, they tell you the different bases. They teach you in your first year of law school when you're learning con law. They teach you the different approaches as to how to understand the Constitution and how to interpret the Constitution. And sometimes it's hard for first-year law students to understand the difference between a textualist approach and an originalist approach. This brief here, put forward by Trump's counsel, does a remarkable job of distinguishing, without really even not that it was its goal, but as I was reading through it, I was like, wow, this is a great distinction. This is a textualist argument. What's a textualist argument? A textualist argument is we're going to focus on what do the words say. And as we look at these words, how can we possibly understand what these words are meant to say, meant to imply? What is the most logical way of interpreting the words as the words are written? That's a textualist approach. So as we're taking a textualist approach and we look at the specific words regarding impeachment, so the impeachment judgment clause, it implies that there's immunity for all your acts unless you're first impeached and convicted by the Senate. How so? Because it says, from straight in the Constitution, it says, in cases of impeachment shall not extend further than to removal from office. So if you're going to impeach someone, makes it very clear. When it's explaining how impeachment works, you know what happens when you impeach someone? If you successfully impeach him, does he get put to death? No. What happens if you impeach him? He gets removed from office. That is the full extent of what happens if you impeach someone. All you can do to someone is impeach him, and when you impeach him, and he gets convicted, he's removed from office. But what happens if he's convicted? The party convicted, and this is the key phrase here, party convicted shall nevertheless be liable to and subject to indictment, trial, judgment, and punishment according to law. Which means that if you get convicted by the Senate, the text says at that point, you can be subject to indictment and trial. What if you're not indicted by the Senate? The most logical reading of this is that the party acquitted is not subject to prosecution. So the clause's plain implication is that criminal prosecution, like removal from the presidency and disqualification from other offices, is a consequence that can only come about after the Senate's judgment, not during or prior to the Senate trial. And that's what Judge Alito wrote in 2020. He was defending his case that he decided, but that's the textualist argument. So far we have separation of powers. Next we have textualist argument. Third point, originalism. What's originalism? How's this different from text? Forget about the text. Let's look at what the thought process is of the people who wrote the text. How did they understand it? Even if it's not written there in plain language, what did they understand about it that they had just performed? So that's clearly what they meant. So that tells us what the law means, even if it might not be expressed in the text. And he took evidence from the founding era. We have evidence of the founding era. First, we have Alexander Hamilton, who wrote the criminal prosecution of president for official acts may occur only after impeachment and conviction by the Senate. Specifically, he wrote, President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes and misdemeanors, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. But if that doesn't happen, he cannot be held liable, which is logical. It's logical. So we're going to come to the common law argument next. They also bring down from Marbury v. Madison that says his acts are only politically examinable. So that's the originalist perspective, saying that way back in the day when they were first drafting the how we handle a president, that's how they understood the rules affect a president. Fourth point, common law. So citing Nixon v. Fitzgerald, which says immunity decisions have been formed by common law. When we're talking about what immunity means, so immunity, first and foremost, means from criminal prosecution, not from civil, not from other stuff, but the most basic form of immunity means you're not going to face criminal charges. They cite United States v. Johnson, which says that common law, the privilege of legislative immunity, because there's such a thing as legislative immunity, that you cannot be held liable if you pass a law and that law leads to the death of thousands of people, that you cannot be held criminally liable. It's legislative immunity. What does that mean? You cannot be held liable. Does that mean you can't be sued financially? Well, first and foremost, it means you can't be thrown in jail. This is a privilege that we give to anyone who writes a law that sucks and is stupid and ends up killing people. All the more so for presidential immunity. The legislature was not born primarily of a desire to avoid private suits. It's not that we're afraid of the guy getting sued, but rather to prevent intimidation by the executive and accountability before a possibly hostile judiciary. So the reason we have, want to know why we have presidential immunity, much like we have other immunities, because if you don't give these immunities, what's going to end up happening is political adversaries going to come along and say, yeah, I'm sending you to jail. You're going to prison. I don't like you. I think that this law that you passed was criminal. I'm going to punish you. So much like we have these other immunities, and we recognize that, hey, you know what? If we don't give these immunities, then in that case, they're political enemies. 10 years, 5 years from now, we're going to come along and try and throw people in jail. And that's going to make people say, I don't really want to have any of this public service, so that my enemies down the road are going to end up basically saying, get the guillotine out. Instead, we say, we're going to give you immunity. That's what common law says. Preventing the instigation of criminal charges against critical or disfavored legislators was the chief fear. The chief fear. Boom. That led to the recognition of the doctrine of immunity. The constitutional practice tends to negate the existence of the power asserted here, quoting, and these are all Supreme Court cases, Prince versus United States, or United States versus Johnson, Shore v. Rhodes. So, just to review, because remember, there's a test. Test is coming, okay? First thing, separation of powers, right? First basis was separation of powers. Second was text. Third, originalism. Fourth, common law. There we go. 3 more reasons to go. Number 5 is history. History tells us that there's a 234-year tradition of not prosecuting presidents for official acts, which supports his claim of immunity. American history abounds, as he writes, with examples of presidents who were accused by political opponents of committing crimes through their official acts. This is not the first time. But you think that what he's doing here, what he did here with this whole election thing, that people are saying, oh, that's a crime, that he's inciting. You think that's the first time someone said a president committed a crime with how he conducted himself in his official acts? No. Yeah, with all goes back to John Quincy Adams, 1824, where he had what was called the corrupt bargain with Henry Clay. A lot of you might be saying, what corrupt bargain with Henry Clay? Well, here's a brief history lesson for you, that when they had the election of 1824, there was Andrew Jackson got the most electoral votes. He got 99. John Quincy Adams got 84. There was another individual there. I forget his name. He was sickly, though, who got like in the 70s. Henry Clay got 37. None of them had a majority. So they said, what are we going to do? Oh, well, let's look at what the Constitution says. The Constitution says we send this back to the state representatives, and they basically decide what's going to happen. Who's presiding over that? Oh, Henry Clay. Henry Clay knew he didn't have enough votes there to win. So all of a sudden, all these people who were supporting Henry Clay, they basically said, we don't like Jackson. Because Henry Clay hated Jackson. He's like, yeah, I'm gonna get behind John Quincy Adams here. Well, I think we're all going to get behind, circle the wagons, get behind John Quincy Adams. And John Quincy Adams, even though he didn't have the most electoral votes, he ended up becoming President of the United States. The day he's appointed, he makes Henry Clay his Secretary of State. Jackson went nuts. He's like, there was a corrupt bargain here. He basically said, oh, okay, I'll take care of the House in order to help you. There was like obvious corruption. But they had this side deal here that John Quincy Adams went over to Henry Clay and said, I'm going to make you like, third in command here if you get me the votes here. And that's the only reason why that he won. That was a completely corrupt bargain. He could have brought him to court. He could have said that there was all sorts of corruption here and tried having criminally charged. Anything happened with that? Heck no. George Bush, all these people claiming that Bush lied, kids died. Which we know he lied, and we know kids died. Was he prosecuted? No. President Obama, it's pretty well documented that he issued a drone strike that targeted and killed a U.S. citizen and his teenage son, also U.S. citizen. That were what country were they in? I don't remember. Somewhere in the Middle East. He literally killed someone. Any criminal charges? Why not? Oh. In each such case, president's political opponents vehemently accused the president of criminal behavior. And yet, none of them were prosecuted. The district attorney came along and said, oh, we're going to try throwing you in jail. You want to know why? Because historically, it's been widely regarded that when you're doing something in your official act, you cannot be prosecuted. It's presidential immunity. Even though all of them had motive, everyone recognized that. That's the fifth point. 6th point. 2 more points to go. 6th point is that with respect to analogous immunity doctrines for legislators and judges, for example, the court recognized Spalding v. Vilas, the doctrine of absolute judicial immunity extends to both civil suit and criminal liability. Likewise, in the context of legislative immunity, the court has held that immunity for legislative acts extends to both civil liability and criminal prosecution, which I'm not going to kid you. I'm not going to try and kid you here. These 2 points that he raised, this point sounds really similar to the 4th point. It's really similar. So we're going to call it like 6.5 points, but he calls it 7 points. So, and the final point is public policy. What's public policy? To me, public policy here is one of the most important points. Why has this been what we've been doing? We want to know why? Because being a president is not an easy job. It's a tough job, and part of it is that it requires bold and unhesitating action and the threat of future prosecution. If a guy who's sitting as president of the United States knows that if he makes the wrong call, that he could be criminally prosecuted for it, that would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of the government. What the hell are you thinking? If this is going to become the new normal, this is what we're going to do going forward. How on earth will any president ever serve without concern that his political enemies are going to take his misstep, which everyone makes missteps, they're going to take his misstep as a basis to throw him in prison? It's ridiculous. It's impossible. It's the stupidest thing in the world. Defending decisions often years after they were made can impose unique and untenable burdens on the president. The prospect of politically motivated criminal prosecution poses a greater deterrent to bold action than mere civil liability. Thus, immunity is particularly appropriate to protect the president's maximum ability to deal fearlessly and impartially with the duties of office. There you go. Those are your 7 reasons. So, quick review here. What do we got? Separation of powers. Constitutional text makes pretty clear you have to be indicted first. Originalism, that's Alexander Hamilton, Robert V. Madison, both of them all say you have to be indicted first. Then we got the common law, which we said was similar to the immunities, which basically is that's just how immunities work. That's the point to having immunities, is that they're not going to have criminal liability, so that people are kind of like, actually able to do their job. And history. And finally, history says that we don't care. We don't care whether or not someone really screws up. We're just not going to go after a president. That's just not what we're going to do. And finally, and frankly, even though, look, I wanted to see Obama thrown in prison for the drone strike, I think there's 1,000 other reasons he should be thrown in prison for the evils that he wrought upon this nation and this globe. But that doesn't mean it would make sense. It would make sense as far as benefiting America in the long run. And finally, public policy. Those are the 7 bases that are brought down there. Hope you all took notes on that. What's the prognosis, Doc? So here's the concern that I have. Here's the concern that I have. I have concerns. This is the if I'm sitting there advising Trump as to the strength here, where, and if I want to find like where is the ventilation system that the bomb can drop in here to destroy this beautiful defense. Here's the problem that I have. I'll give you my biggest concern. I'll give you that in a moment. Let me get through the super chats and I'll give you my biggest concern. Need a bibliography now, right now. Don't trust your chat GPT answers. That's true. That's true. Jenny. Hello. Very, very nice slides, Joe. Thank you. Thank you much. I appreciate that. BioGuide Congress. So what? How am I supposed to do with that? What do you want me to do with that? What the heck am I supposed to do with that? Tell me. What? I don't know what's happening here. I'm checking through the I'm checking through my diggers over there in locals, and they are not impressed. Not impressed with my PowerPoint. Stop it. Everyone loves PowerPoint. Don't tell me it didn't make it easier. It made it much easier than me simply reading those 6 pages to you. Much easier. See, this is where we're at over here. I get to jump now to page 25. Boom. Mm, 24. Oh, 25. There we go. Told you. Totally worth it. 7 slides instead of 6 pages. Totally worth it. I don't know what you want me to do with this. What do you mean is that? What is that? Let me see if I can find it. Gosh. What is that? Where are you at? I know what you want from me, Grimsbar. BioGuide Congress. I can't. All right. So we move forward here because I want to work my way through the balance of this here. But I promised I was going to give the prognosis doc, and I was going to give you this. So before I go any further, I'm just going to tell you, here's the problem. Here's the problem. If I want to try and view this as objectively as possible, which I think is the healthiest way to try and approach things, and I look some situation 50 years in the future, okay? Unless there is a bright line rule that you cannot be criminally prosecuted for anything that you're not impeached for. When you have this issue, the way it's framed by his counsel, that you cannot be prosecuted for any acts within the outer perimeter of your official duties. Here's the problem. Who's defining what acts are within the outer perimeter of your official duties? What is the yardstick for determining when something is or is not within the outer perimeter of a president's official duties? And what that basically does now is now you have a little bit of a problem, because does that mean who's supposed to determine? And this seems like a question of fact. Forget about Trump, okay? One day, 30 years from now, we're trying to decide whether President Quantos did something illegal and whether or not it was within whether it was within the outer perimeter of his official. Their official. Their official acts. Now, of presidential acts. Now, sorry if I just made you throw up in your mouth. Okay, so now, who's making this determination as to whether or not it was within this outer perimeter? And what is the yardstick for making that determination? Does it not necessarily flow from there that is an issue of fact as to whether or not something is within the or without, meaning it's beyond the outer perimeter of their official acts, which would require ultimately that there be some fact finding, meaning a jury that's going to sit here and make a determination. Do these acts fall within the outer perimeter of your presidential duties? And that can be somewhat disconcerting. And I can see certain of the smoother minds on the Supreme Court making this into like some sort of hang-up where they are where they basically start opening up that doorway for a completely partisan jury to basically say, oh yeah, this person's acts are totally outside of their presidential duties, whereas any other president, they would say, was totally within their presidential duties. In which case, you're now walking down this road of having the whole political, you're back into square one. You're back into that problem of all these different issues that we were addressing here, as far as there being, violating public policy. You're back into the whole political element of things. All the different issues that we just outlined in those 7 points, you're back into all of them. And you basically you're throwing all those out the window. Because as soon as if we start having proceedings to start determining whether or not acts that are potentially criminal are going to be deemed within the penumbra of presidential duties, good luck finding use of the word penumbra outside of Roe v. Wade, but I did it. So if it's in the penumbra of presidential duties, now this is going to become a political question. Where your political enemies will be like, oh, you know what? I'll take you to jurisdiction. Like, you know, if you're on the right, I'll take you in DC. If you're on the left, I'll take you down to like Texas or whatever, and I'll sue you there. And basically try and assemble a jury together that hates you. That's going to say that these particular acts are outside the penumbra of your presidential duties. Look, sometimes things are clearly within your presidential duties. Like I said, as much as I think that Biden sucks and Biden should, you know, it deserves to like force Dante to create an eighth circle of hell for the terribleness that he's done, and one of them being the cluster fart in Afghanistan. But it's inarguable that that's within his role as the commander in chief. So I guess that's inarguably within that orbit. But you start talking about outer perimeter of presidential duties, then you're going to start walking into murkier territory. And that is where he could. That's the only place I see Trump can trip here. But they'll be like, there's no official duty for you to oversee elections. That's not part of your presidential duties. It's not squarely within it. It definitely seems like it's in the outer perimeter. To me, it's definitely within, like, okay, that's a presidential type of thing to do. When you're talking about what the vice president should do, he has more of a duty in that role than I do, or than you have, or than some congressman or senator has. He has more of a role in that orbit. Is it part of his executive functions to oversee state elections, make sure the state elections are being run properly, to ensure that the federal election result is proper? Yeah, I definitely see it. My first take was definitely. The more I thought about it, I was like, yes, but less concrete, especially someone like me, who's a very strong proponent of strong local governance. So if you're like me, if you have if you have a real federalist type of perspective that, hey, there's supposed to be strong local governance. So the idea of the president of the United States overseeing all elections across the country, and that's his primary job, it's on kind of shaky. It's on shaky terrain. It's on a little bit shakier terrain the more you think about it. Now, would it fit what I would define as being the outer perimeter? Definitely, 100%. But it's not like it was, you know, a question as far as a wrongful act in foreign relations, like Bush lied, kids died. And that's all part of his whole foreign affairs, right? So that's the only concern that I have. So if you ask me, where's my vote? Definitely, of course, that this is within the perimeter of what the president's supposed to be doing. It's certainly much more what he's supposed to be doing than what you or I are supposed to be doing. But is it something that, like, he must do? He must oversee that? I don't know. The same way, if let's imagine that Biden comes up there, that God forbid President Gavin Newsom, right? Let's say President Gavin Newsom pushes forward a thing which basically says all Americans have to own electric vehicles. And as a foreseeable consequence of this inept decision, within 3 years, all these cars are breaking down, America is bankrupt, and we're basically, like, other troops come marching in. I mean, it's just completely inept and stupid. It overtaxes our power grid across the country, and the entire country is desolate, so that, like, even like schmucks from like Costa Rica are able to invade our country, and people are starving, and the economy gets shot to hell, and we can't afford to pay our troops anymore. God forbid there's chaos and mayhem, and dogs and cats are living together. So now someone says we need to throw this guy in jail for this incompetence, for this negligence, this ridiculous, you know, that led to countless thousands that foreseeably led to countless thousands of deaths when hospitals were forced to shut down because they didn't have any power because of this schmuck deciding that he needs to have more Humvees as EVs across the country. So like now when those that financial and that loss to life and limb in finance across the country, and we're destitute, and that's all foreseeable, and people are dead because of him, and that's all foreseeable. Now people want to charge him with this criminally reckless negligence that led to all this horrific things, which I think is like with the visual I'm portraying under a President Gavin Newsom is probably like a good scenario of him being president. Oh my God, what a disaster he would be. But so is that within his presidential or why are you dealing with the climate? Why are you dealing with the economy? Is that part of your presidential role? Is that part of like what the hell does that have to do with you? I would certainly be making that point. Now, presidents have continually tinkered with the economy, so I can understand the counter saying, oh, it's within the ambit of what he does, within the outer perimeter, what the president does. But I think when I portray it that way, you can better understand where the other side is coming from when they're like, you're just kind of extending out a perimeter to protect your guy. This is me doing my damnedest to try and look at this as objectively as possible. Like I'm really trying to just like look at this as fairly and logically as possible. So this is the flaw with the whole argument in general. Pam. Perhaps bouncing letters and fades for everyone's feet, locals. What? For everyone's... I don't know what that means. What? I don't know. Will the PPT be available for download on locals? Oh. I could do that. I hadn't thought about it. PowerPoint? Well, locals? I could do that. Yeah, why not? I gotta just delete that slide. Cut. Yeah, I can totally do that. I'll do that later today. I like it. Sure. Jeff Bezos banned PowerPoints on Amazon for a good reason. Did he? Come on. Everyone's hating him. Do you think Gorsuch having 10th Circuit as his assigned circuit influences at all whether SCOTUS addresses this? I don't think so. I don't think it's going to have much of an influence on that. Ed! Chief Justice Robertson said presidents aren't officers. The people do not vote for the officers of the United States. They instead look to the president to guide the assistants or deputies. When did he say that? When did he say that, Ed? I want to know. Presidential duties, yes, no, is what impeachment is for. Oh, I agree with you on that. I mean, that was the second point. Second point was constitutional text. This time I tried baiting Joe for medical advice, but he answered seriously. The time I tried baiting Joe for medical advice, but he answered seriously. What's the prognosis, Doc? Oh, I see you. Why don't you go live with this on your Trump Trials channel? How many hours do you have over there? I met my hours requirements, so I'm good on that. I'm waiting for the approval. So I'm like, why the heck would I give them views that they're not going to that they're going to basically probably run ads on, and I'm not going to make any money on it? No, the hell with them. I already do too much for YouTube. That's why. It's a good question. Fair question. Logical question. Anyhow, let's get back to this. Okay. I'm going to run through the rest of this decision because I think we got to the main part of what I wanted to cover here. No, not decision, excuse me. This is the brief that was submitted by Trump's counsel. A very well written brief, I want to add. So, District Court's decision on December 1st, 2023, 9 days after the close of the briefing, relevant notes, District Court comes out and says, Trump, you lose. And on the question of presidential immunity, District Court held the doctrine of absolute presidential immunity does not shield a former president from federal criminal prosecution for his official acts. And the court denied President Trump's claim in toto. I don't know if you've ever heard that anyone use the phrase in toto. I will tell you, it's a phrase my father, great Lawgic, used all the time when I was a kid. In toto. Once they did that, so now, because they held that there was no immunity, they didn't address whether the acts alleged indictment fall within the scope of the presidential's official duties. Because they said even if it does, because this is now that's still they're recognizing he's recognizing it's a question of fact. Do these fall within it? First, you have to decide: do we get, and they really might decide on that basis. And they might decide in favor ultimately on this issue, and then try and have to raise the question of what's considered an official act, official duty. Regarding Trump's double jeopardy argument, district court held that neither traditional double jeopardy principles nor the impeachment judgment clause provide that a prosecution following impeachment acquittal violates double jeopardy. Then we filed a timely notice of appeal with the D.C. Circuit Court. Special counsel filed a motion to expedite it. D.C. Court said sure. D.C. Circuit Court. So now, here are the reasons for denying the petition. This is why we don't want to come running into court, Trump's team says. This court's Rule 11 provides that petition for certiorari before judgment will be granted only upon a showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination of the courts. Now, Jack Smith emphasizes the imperative public importance of the case, but he provides virtually no explanation as to why that importance justifies deviating from normal appellate practice or requires immediate determination of the courts. Prudential considerations weigh against certiorari before judgment. So it's an interesting concept that they're going to basically weigh in on over here. Where they said the court has often emphasized the value of percolation. Meaning that you sort of leave things on the fire and let it cook through the judiciary. Let's see how different judges weigh in on this. Let's see how different courts feel about this. If that's a better way before the Supreme Court comes down and goes funk, then we sort of want to see where the lower courts feel about this. They're pretty smart people there too. What are their thoughts? Allowing lower courts to first carefully consider novel and difficult questions of law. It often would be preferable to allow several courts to pass on a given claim in order to gain the benefit of adjudication by different courts in different factual contexts. A rule freezing the first final decision rendered on a practical legal issue and allowing only one final adjudication deprives this court of the benefit it receives from permitting several court of appeals to explore a difficult question before the court grants certiorari. They must have been very nervous when they wrote this paragraph, because basically what you're saying is there should be a few different cases that come up before you ever weigh in on this. Well, what if you lose for a D.C. Circuit Court? You're going to say we need a few cases? I'm not crazy about this point here. But here, special counsel urges that no courts of appeals should be allowed to explore the difficult questions before this court grants certiorari. He's incorrect. This litigation exemplifies the wisdom of allowing difficult issues to mature through full consideration by the D.C. Circuit Court. It often eliminates many subsidiary but still troubling arguments and simplifies the court's task by winnowing arguments through adversarial testing. Did I miss my Gorsuch chat, or did I miss the answer? Do you think Gorsuch being assigned 10th Circuit has influence on whether SCOTUS takes this? I don't think it does. I don't think it does. What? I also wasn't sure. Let me see something. So I'm not sure why you keep saying that. Where I'm like, the D.C. Circuit Court, the 10th Circuit is in the Midwest. So I'm not sure. Are you saying because of Colorado? That's what you're talking about. I'm so confused. I'm sitting here talking about this D.C. case, and now you're talking about Gorsuch being in the 10th Circuit over there. I'm not sure as far as on the process, as far as granted certiorari, as to whether or not. I know that the first initial review is done by that justice, and they have a right to reject it out of hand. I think they have the ability to reject it out of hand. But I never really looked into the whole procedural basis as to like how this certiorari gets granted and the initial review, when you're talking about the Colorado decision yesterday. So I don't think I can give you I don't think I can give you an informed answer, and I don't want to guess. You asked me like basically a question about legal process. I don't think it's helpful to you if I guess. So, but my guess is yes. There you go. Hope that answered it. Biden should be charged with inciting violence every time he calls us white supremacists or black universities. That's a fair point. That's a great point, Lily. Good to see you. Happy holidays. It's December 20th. We're like really in Christmas season now. We're really in Christmas season. All right. Issuing the writ before judgment also has potential for producing splintered decisions. That potential is magnified when there has been no prior panel consideration of a case. Thus, bypassing the winnowing function of the Court of Appeals is something this court routinely refuses to do. Special counsel Jack Smith notes that this appeal involves questions of extraordinary importance. This case presents a fundamental question at the heart of our democracy. Only this court can definitively resolve. This case involves a paradigmatic issue of imperative public importance. Indeed, one is at the apex of public importance. Okay. He keeps going on and on about that. And yeah, an erroneous denial of a claim of presidential immunity by the D.C. Circuit Court. We're definitely going to want your review on that in due course. But importance does not automatically necessitate speed. Just because something's important doesn't mean it has to be decided in 10 minutes. If anything, the opposite is usually true. Novel, complex, sensitive, and historic issues, such as the existence of presidential immunity from criminal prosecution for official acts, call for more careful deliberation, not less. When a case arouses keen interest, courts should respond to that circumstance in a calm, orderly, and deliberative fashion. Not sitting here before, the window closes at 5 o'clock. Judicial orders warrant the utmost respect when they are perceived by the public to have been reached at the most regular and careful manner. Indeed, the fact that this case arises in the vortex of political dispute warrants caution, not haste, especially when they're considered too quickly. Great cases, like hard cases, make bad law. For great cases are called great, not by reason of their real importance in shaping the law of future, because of some accident of immediate overwhelming interest which appeals to the feelings and distorts the judgment. Quoting Northern Secretary Company versus United States from 1904, Justice Holmes dissented. This case, which is both great and hard, exemplifies the need for cautious, measured, deliberative approach. Oh no, we need a 15-second health break. And we're back. I haven't checked up on you guys in so long. Hey, Real Patriots Party. Bite me. Whew. All right. Special counsel identifies no compelling reason to haste. To justify departing from these principles, the special counsel offers the naked assertion that public interest demands that this appeal be decided in the current term. That makes no sense at all. First of all, how do you know? Did you take a poll of public interest? Special counsel requests a substantially compressed briefing schedule that would virtually guarantee cramped, incomplete presentation of issues. Jack Smith justifies this This request with vague references to the supposed paramount public importance of holding President Trump's potential criminal trial as expeditiously as possible. Why? Why? Jack Smith demands immediate resolution of the immunity question so that the trial may occur on an appropriate timetable. What's appropriate? What's an appropriate timetable? But in an omission that speaks volumes, Jack Smith never explains why March 4th, 2024 is supposedly the only appropriate timetable for this historic prosecution. Okay, why do you leave that out? That date has no talismanic significance. The great talisman that's waving over March 4th. The prospect that an interlocutory appeal of an immunity question might affect a pending trial date is a routine feature for such cases. This happens all the time. Especially in cases of extraordinary public moment, the individual may be required to submit to delay, not immoderate in extent and not oppressive in its consequences, if the public welfare of lands will thereby be promoted. Land is a North American company, 1936. A mere assertion of delay does not constitute substantial harm. Some delay would be occasioned by almost all interlocutory appeals. Moreover, whereas here the D.C. Circuit has dramatically expedited proceedings on appeal, any delay will be minimized by its expedition in hearing this appeal. In short, there's no reason to believe a minor delay will substantially harm the United States. The special counsel's request creates a compelling appearance of partisan motivation. They're a bunch of stinking, freaking partisan. Oh, we're here so innocent. No, you're here to try and screw over your political enemy. That's what this is all about, Jack Smith. That's what you're about. You're all about, I can't stand the Republicans. This is all about you're trying to protect your big lackey. You're a lackey for your big boss, Joseph R. Biden. That's what you're displaying from your extraordinary request here, combined with your vague, threadbare justification that there's some sort of compelling appearance or partisan motivation to ensure that Trump, the leading Republican candidate for president with the greatest electoral threat to President Biden, will face a months-long criminal trial at the height of his presidential campaign. That's what they want to do. Sit there fighting out to stay out of jail instead of going out there campaigning and beating your lackey, your loser, deranged, incompetent boss, Joseph R. Biden. That's what this is all about. That's the only pressing public need. The current potential trial date of March 4th falls the day before Super Tuesday, one of the most critical dates of the Republican primary calendar. Special counsel's insistence that this court decide this immunity question during its current term reflects the evident desire to schedule President Trump's potential trial during the summer of 2024. Obviously, that they just want to basically go to trial during the last months leading up to the election. At the height of the election season, this is all in light of the fact that the case brought and now sought to be rushed by the special counsel attempts to criminalize official acts taken by President Trump in late 2020, early 2021, 3 years ago. They waited till now, till all of a sudden they start bringing this criminal prosecution. Jack Smith's request, therefore, cannot avoid the appearance of partisanship. This court is not required to exhibit a naivete from which ordinary citizens are free. Let's stop pretending that you don't understand what every other American knows. You know it. Everyone knows it. Everyone knows why they're doing what they're doing and when they're doing it. You don't have to pretend to just like, oh, really? Is this about partisanship? As soon as Jack Smith's petition was filed, commentators from across the political spectrum observed that its evident motivation is to schedule a trial before 2024 presidential election, a nakedly political move. Everyone saw it, and you know it too. And you don't have a duty to pretend that you don't notice it. Did they quote me? Am I quoted in there? I don't think I'm quoted in there. No, I quote the Washington Post. Wall Street Journal. I'm not quoted. Oh well. Could dare to hope. In Scotland's request, Jack Smith repeatedly says it's super important Trump immunity issue be decided quickly, but doesn't say why it must be decided quickly. Obviously, that Trump can be tried, convicted, and sentenced before 2024 election. Why not just say so? It's a great quote. Jack Smith thus confuses public interest with partisan interest of his superior President Biden. Nice. The petition echoes Charles Wilson, former president of General Motors, who's supposed to have said, what's good for General Motors is good for this country. Those in power, even giving them the benefit of the greatest goodwill are inclined to believe that what is good for them is good for the country. So also here, special counsel and Biden administration to which he reports are inclined to believe that what's good for them is good for the country. Tens of millions of American voters plainly disagree, thus creating an electoral threat to those in power that evidently drives the extraordinary request. Jack Smith's politicization of this trial schedule, including in this petition, departs from the best traditions of U.S. Department of Justice. You're embarrassing yourself, Jack. You're freaking embarrassing yourself. Federal prosecutors may never make a decision regarding an investigation or prosecution or select the timing of investigative steps or criminal charges for the purpose of affecting an election. That's not what your job's supposed to be when you're the head of the DOJ or you're working with the DOJ. I guess I was talking to Merrick Garland for a second. Even worse than Jack Smith's request threatens to tarnish this court's procedures with the same appearance of partisanship. Why would you give in to this? What are people going to think that you're giving in as far as this rush date? That you think it's so important? You're going to breach all your normal protocols? Say he can get his trial before an election? Why would you be doing that? That makes no sense. Great point. Great point here. Special counsel tries to drag justices into his political timetable for January 6th trial of Donald Trump. Now he's dragging the Supreme Court into the political thicket. Jack Smith urges the court to jettison venerable principles of prudence. Prudence. Leapfrog the ordinary process of appellate review, rush headlong to decide one of the most novel, complex, and momentous legal issues in American history. In doing so, Jack Smith seeks to embroil his court in a partisan rush to judgment on some of the most historic and sensitive questions that this court may ever decide. The court should decline that invitation. The cases the special counsel cites do not support the petition. Special counsel seeks to compare this case to a handful of cases which court granted certiorari. They bring up United States versus Nixon, but that differs critically because Nixon concerned president's assertion of executive privilege against criminal subpoena. Now, I want to be fair with you on something here. There were a couple of issues here, which we're talking about presidential immunity, that Trump has lost before this Supreme Court, where he said, I have immunity. And this is something you should be aware of because this might come up, where this court says you don't have absolute immunity when it comes to presidential subpoena. So you might come to a certain conclusion. I just want to sort of walk you through this thought process here for a second. This is something that floated through my mind. All right, so this particular SCOTUS has already ruled that Trump is not immune when it comes to subpoenas. Well, what's the purpose of a subpoena? The purpose of a subpoena is likely for criminal investigation. So why would you assume that there's any sort of presidential immunity if the Supreme Court has already said that you could be subpoenas and that criminality can be investigated? The purpose of investigating it likely would be to prosecute you, which implies that if they think you'd be investigated, you can also be prosecuted. I don't think that's a crazy thought to float through anyone's mind. At least it wasn't too crazy to float through my mind. But the answer to the distinction, though, is maybe they felt like the reason you can have those subpoenas and be subject to them is because otherwise you might be able to hide politically from the public various things you're doing wrong. So the reason that a president should be exposed to subpoenas is to force him to have transparency, so you can't act corruptly, and it's without the public being able to vote him out of office and recognize what he's doing, or to stop him from being impeached. But that's not the same thing at all as saying that because he's subject to subpoenas, he's also subject to criminal prosecution. So I wanted to draw that delineation for you because it is a thought that went through my mind. But I think that's a pretty important distinction. The far more momentous question whether the president himself could be indicted and be forced to stand trial for his official acts were not an issue. Also, in Nixon, it's not right on a blank slate. The whole issue about executive privilege and criminal proceedings had received extensive, thoughtful discussion in prior appellate decisions. So when they were rushing through it in Nixon, it's not like that was the first time it was coming up before anyone. So Here, by contrast, no current or former president has ever been criminally charged for his official acts before, and no appellate court has ever addressed whether the president has immunity from prosecution for official acts. Because even a single opinion from the Court of Appeals is likely to assist the court in its ultimate resolution of the issue, this litigation exemplifies the wisdom of allowing difficult issues to percolate, mature through the full consideration by at least one Court of Appeals. Citing Train. Third, procedural posture in Nixon was very different, involved in an interlocutory dispute over a subpoena ducis tecum. Delay in that case, therefore, would have directly implicated the rights of specific third parties, but over here, no one's rights are being affected. Then he brings up Biden v. Nebraska, and he distinguished from Biden v. Nebraska by saying that they involved petition for certiorari before judgment filed after the 8th Circuit issued a nationwide preliminary injunction against the challenged student debt cancellation plan. So there, that went straight to the Supreme Court. So furthermore, the decision directly implicated the rights of third-party millions of students and borrowers. It's affecting millions of lives. What's going to happen? So there, you can understand that's why it's getting expedited. That's why it's coming straight to the Supreme Court. Because this is, you don't want to have that sit around. We have millions of Americans who are dependent or hoping to get thousands of dollars. So that's why that got rushed there. That's not really relevant over here. Department of Education v. Brown adds nothing to the analysis, as it involved a challenge to the same policy that was decided in the same day as Nebraska. So, same thing. United States v. Texas. Fifth Circuit had issued detailed opinion denying the government's stay application that addressed both standing and merits and conflicted with a recent decision of the Sixth Circuit. Thus, there were detailed opinions from two different circuits, and the government faced specific immediate irreparable harm from delayed review. But over here, basically, you have no harm, and that's why it's not relevant. And then they get into the district court's the hazards of hasty decision making and all the different problems that come when they're issued quickly. I'm not really that concerned with that. I really want to get down to the bottom here and just share with you this. So this is done by John Lauro. At least he's the one who's the chief name on this. I think these are very well drafted documents. Also by Todd Blanche and the James Otis Law Group. Counsel record William O. Scharf. I think this team did a pretty strong job putting this together. But at the end of the day, the key things I want you to think about with respect to presidential immunity are this. Is it seemed pretty clear that if he's doing something within official acts, that he's definitely should be free. There should be presidential immunity unless he's been convicted by Senate for impeachment. I think it's difficult to argue otherwise. But even if that's true, there still is an issue that he's going to be left to overcome, which is that these actions that he's accused of committing fall within the ambit of presidential duties. So he could win before the Supreme Court. This could be appealed. Whatever happens, the D.C. Circuit Court is going to go to the Supreme Court. Supreme Court could find in Trump's favor that yes, official acts are with that, or anything that's within the penumbra of official duties would give you protection from facing any sort of liability for criminal liability. But that maybe these acts don't qualify as being within that umbrella. And if that happens, in that case, one could make a claim that, well, at that point, he's not going to get the presidential immunity because these actions are outside that umbrella. And then there would be legal arguments regarding whether or not, as a matter of law, these should be considered within that umbrella. And that would be a second win he would have to have from the Supreme Court. So this is not something that's going to be resolved quickly. I think this is going to take a while. I think it's going to take a while. Will they give expedited review? I don't know. But I think it's going to take a while for them to reach that conclusion with respect to these charges. Unless they knock it out saying that because these are the charges that he won in the Senate, that they go for the double jeopardy claim, that would knock it out in one fell swoop. Presidential immunity for acts that are within your official duties, that would not be one fell swoop. That would be two swoops, because first you have to establish that is an immunity that he has, and then the second issue would be, were these within that orbit? You would hope that the Supreme Court would at least give some guidance in such a case as to what's considered within that orbit, and say something like, hey, election stuff is within that orbit. You would hope they would give that inclination to push Chutkin down that road. But it's far too early to have any sort of perspective as to how the Supreme Court is gonna fall over here. That's my take. I don't think any of that's going to happen before the 2024 election. I think we might get decisions on this part. That's possible. But I don't think we're going to see a trial. I don't think we're going to see a criminal trial before the 2024 election. That's my story, and I'm sticking to it. My name is Joe Neerman. People call me Good Lawgic. Well, if you're here, you can like, subscribe, drop a comment down below. What do you think about presidential immunity? Do you think that there's certain bases that I brought up or that were raised in this brief that are kind of thin? What do you think is the best basis of it? I really want to get your thoughts on that. I'd like to hear what you have to say. I'm here all the time, Joe, just quiet. Well, I still like hearing from you. So, impeachment required for acting out of duty scope. Maybe. If that's the case, if you require impeachment for that, okay. That's a fair claim. We don't. It's so the Supreme Court can go in so many directions on that we don't know where they're going to go. We don't know where they're going to go. So that's why it's really early. I'm simply saying I can see scenarios where there's logic would dictate that based on how the Supreme Court reaches its determination, that you could get a win here without it being something that actually completely slays the Jack Smith, the beast. So just making that point. I think he's going to win. I don't think he's ever going to be convicted of any of these things. But depending on the nature of how he gets a win in the Supreme Court, I think he's going to get several wins in the Supreme Court. But depending on the nature of those wins will affect exactly how thorough a slashing this is to all these different allegations, all these different charges against him. That's my show. God willing, tomorrow I'm going to be doing the locals, and then I'll be back here tomorrow evening. I'm going to have a guest on here soon because I feel like I need some company. So stay tuned. Make sure you like, subscribe, share with all your friends and neighbors. Give them the Christmas gift of Good Logic. Till then, make sure you stay happy. Godspeed. Whoops. Make sure I'm drunk. Stay happy. Eat the bugs. And as always, Godspeed.